I'm criminal defense attorney Ryan Pasiga, and I'm going to talk about entrapment. And it's one of those really misunderstood defenses under the law. For example, people have asked if an officer is sitting on the side of a highway with their lights off at night and you get caught speeding, is that entrapment? And the answer is no. Or if an officer asks you questions after they pull you over, like have you been drinking, and you answer, is that entrapment? And again, the answer is no. So entrapment, the law is a little bit different from state to state, but I'll give you the general law in Minnesota. Basically what entrapment is the police causing you to commit a crime that you would not have otherwise committed. And that can be either directly through the police or through the use of some of their informants, but it's not as easy as it sounds. It's actually a really limited defense. So the first thing is that the defendant, meaning you and your lawyer, have to prove by what's called a preponderance of the evidence, which means just slightly more likely than not, or 50.1%, that there was some use by the police of some sort of temptation for you to commit a crime that you otherwise wouldn't have committed. And that can be done by things like persuasion or pressuring you or badgering, for example. There are some cases that say if they use an informant that tries to have sex with you in order for you to give them drugs or something, that could be a form of entrapment, for example. After you prove by a preponderance of the evidence that there was this persuasion, then the burden shifts to the government to prove beyond a reasonable doubt that the defendant, meaning you, were predisposed to commit that crime, even if there was some of this pressure or persuasion. And they can do that by looking at your past criminal history, or even your past reputation for things that you would or wouldn't have done. Whether if this is a drug case, whether you've used drugs in the past, or whether you've rejected drugs in the past, or some of those other sorts of factors. So each case is unique in that analysis. There's another form of entrapment that's a due process form of entrapment, and that means that there's just extreme government conduct. There's been in some cases in Minnesota, for example, where an officer went into a massage parlor and got so far as they were looking as to whether prostitution was being committed, and the officer went so far as to actually let the masseuse massage his genital area, and then only after that had happened, then decided to arrest them for that. And the court in that case ruled that that was just extreme government conduct that shocks the conscience, and even if the person would have been predisposed to commit that crime, they threw the case out because it was so extreme.
Officer!
But again, that's a pretty rare event that entrapment will carry through that far. I have had cases, in fact, where a case, for example, where law enforcement used an informant. That informant was engaged in sexual activity with the defendant, and we believed was using that sexual activity in order to finally convince him to obtain some drugs for her. We filed a motion regarding the entrapment in that case, and eventually the case went away for the defendant. But that, again, was a pretty extreme situation of entrapment.